In family law property matters here in Australia, the court can disregard or discount liabilities in certain circumstances. If the court is satisfied that the debt or particular debts are vague, uncertain, unlikely to be enforced, or if they were unreasonably incurred, then the court might discount those debts or disregard them completely. In practice, I see this issue pop up a lot when someone has lent money from their family members. Often I'll see a child who has lent money off their parents, and then after separation, they say, well, hold on a second, that debt needs to be taken into account, and that debt reduces the asset pool, the property pool that's available to us. Now, what the case law shows, and I'm going to do a case summary in this video of a 2026 case of Hand in Hand, it deals with this exact issue. In that case, the court decided to disregard a debt from the husband's parents of over $4 million. But the point of this video is that even when there are properly drafted commercial loan agreements, the court still has the power to disregard liabilities in certain circumstances. So if you're interested in this topic, stick around. Let's talk about the 2026 case of Hand in Hand. You can read Hand in Hand 2026 for free using Ostley. By way of a brief background, the parties married in early 2018. They separated in December 2021. There was one child of the relationship who lived primarily with the mother and spent time with the husband. So Hand in Hand is an appeal. At first instance, the primary judge found the parties' assets and superannuation were valued collectively at $7,401,418, though the constitution of the property pool was the subject of considerable factual contest. The primary judge disregarded a large debt of $4.66 million that the husband claimed he owed his parents, disregarded the debt of $100,000 the husband claimed he owed his father, and accepted the wife's savings were only $12,906, not $50,000. There were some other things. The court accepted the wife didn't have an asset in the form of an unpaid loan of $25,000 owed by her sister, accepted the husband had no proprietary interest in a vehicle owned by a corporation, and also accepted that the husband did not have an asset in the form of shares worth $19,000. The parties held surprisingly divergent views about their contribution-based entitlements. The wife contended for her entitlement of 30% to the net assets. The husband contended that her entitlement should be measured at 35% of the net equity of a single asset, being the former family home, which equated to 9% of the overall assets. The primary judge assessed the wife's entitlement to be 25% of the total assets. In addition, the wife sought 34.6% of the parties' combined superannuation interest, which aspect of her application the husband did not meaningfully address, and so the wife's contention was accepted. All right, so on appeal, in effect, the husband now contends that the wife should pay him $837,000 for the privilege of acquiring sole ownership of the incumbent former family home, thereby abandoning the different proposal he made at the trial for her to pay him over $1 million. So the difference being $251,000. The husband maintains there should be no superannuation splitting order, and he now seeks a result which is about $900,000 more favorable to him than the appeal judgment provides. There were 3 grounds of appeal. The first was the father challenged the trial judge's decision to disregard the debt he owed to his parents of over $4 million. Secondly, he challenged the validity of the finding made about the wife's proportional entitlement to the assets. And then thirdly, he challenged the finding made about the wife's proportional entitlement to superannuation. Now, in this summary, I'm just going to focus on the first challenge, which is the husband saying that the court shouldn't have disregarded the debt of $4 million owed to his parents. Let's talk about the actual debts. The husband opposed to purchasing a parcel of real property in Melbourne in 2003 for $1.15 million. The purchase was enabled by borrowing about $1.179 million from his parents and 5 corporations they control. He later borrowed an additional $634,000 from his parents to assist with construction of a home on the property. The husband entered into a loan agreement. So again, we have a loan agreement in respect of those advances in February 2004, which was replaced by another agreement made in November 2007. Although the capital advances amounted to about $1.8 million, the remainder of the debt, about $2.8 million, was said to constitute accrued interest. Okay, so we have a situation where, he's borrowed money, there's a formal loan document, and there's some interest. So shortly after the second loan agreement was struck in 2007, the husband's mother and the 5 corporations registered a caveat over the title of the property, alerting their asserted interest in the property pursuant to the charge granted to them by terms of the agreement. The primary judge accepted the husband borrowed money on the terms reflected in the second loan agreement. His Honour also accepted that the loan was not statute barred. However, the husband failed to establish either the quantum of the debt or the likelihood that it would be enforced against him. So, the loan was disregarded as a liability for which the wife should share responsibility. The husband contends the primary judge's approach was flawed because once the debt was proven to be an existing liability, His Honour was then obliged to take it into account by commensurately reducing the net equity in the parties' assets available for distribution. He asserted well-established principles precluded the primary judge from disregarding it. And now we're going to talk about why the husband was wrong. In essence, the husband is arguing there is a legitimate debt, we've got a proper agreement, it was not right for the trial judge to disregard that debt, thereby increasing the net equity that's available for distribution between him and his ex-partner. Paragraph 24, the court explains that the court has wide power to designate the way in which the party should bear responsibility for existing liabilities. So the husband's saying that it was wrong. It needed the debt needed to go on the balance sheet and it should have been taken into account. And the court's saying, well, look, we identify the liability, but it's well within the court's power to decide what happens to that liability. And in this case, the trial judge was correct. They were within their power to disregard the debt. The court goes on to discuss the seminal case of Biltoft, and it says at 31, it has been of equally long-standing practice for the court to be discerning about the treatment of debts owed by spouses to creditors, as some circumstances may require some liabilities to be disregarded or allocated exclusively to one spouse for payment from his or her individual share of the divided property. In Biltoft, the full court said this in respect of the departure from the orthodox practice of deducting known liabilities from the gross value of the spouse's assets, and I quote, notwithstanding the general practice which has developed, the court has indicated that it may properly determine not to take into account or to discount the value of an unsecured liability in certain circumstances. Such liabilities would include, but are not limited to, a liability which is vague or uncertain, if it is unlikely to be enforced, or if it was unreasonably incurred. Now, in cases where we're talking or you're arguing that a particular liability should be disregarded, this is the passage that lawyers often quote. It's this passage from Biltoft. So you're looking at and considering the evidence as to whether the debt is likely to be enforced, whether it's vague or uncertain, or whether it was unreasonably incurred. Now, Biltoft uses the words unsecured creditor. And so some people might say, well, Biltoft only dealt with unsecured loans. You know, if you've got a formal secured loan, then the court can't disregard it. The court addresses that at paragraph 35, and it basically says, doesn't matter if it's a secured loan or an unsecured loan, the significant factual issue is always the likelihood of the debt's enforcement, regardless of whether it's secured. Paragraph 36, the court says, to illustrate the point, there is evidently a material distinction between, on the one hand, a liability owed by a spouse to an unrelated commercial creditor, like a bank, secured by a registered mortgage over real property, and the other, a liability owed by a spouse to a close associate, like a family member or a friend, equitably charged over the property. Both the closeness of the connection between the debtor spouse and the creditor and the type of security held by the creditor bear upon the likelihood of the debt being enforced, and hence the way in which the debt is treated in an exercise of discretion. So much has been recognised in many cases other than Biltoft. Para 42, the court quotes another full court case of Rogers and Rogers, and it talks about how the manner in which a particular liability should be treated is ultimately dependent on the nature of the liability, the circumstances surrounding the liability, and the dictates of justice and equity shaped by each. There is no statutory prescription which suggests that any such treatment of the liability is mandatory. So the judge can form a view, even if there is a formal document, a formal secured liability. The court can still form a view that it should be discounted or disregarded. It's still up to the court in relation to how that debt is treated during the family law property settlement matter. So a common misconception you hear from people is, oh, no, I got a formal loan document drafted. The commercial lawyer might not practice family law. And they live their life thinking, oh, if we ever separate, I will get the money back. And then separation happens, they call in the debt, and you face these types of issues. Ultimately, the appeal was dismissed. The wife sought her cost of the appeal from the husband, calculated on a party scale basis of $27,000, and the husband conceded in the event of dismissal of the appeal. So what do you think about the fact that even if you've got a formal loan document, if the court forms a view that the particular loan is vague, uncertain, unlikely to be enforced, or due to the circumstances surrounding the debt, that the court does have the power to disregard or discount the particular liability. Does this come as a surprise to you? Let me know in the comment section down below. As I said at the beginning, you can read this entire judgment for free using Ostley. And as always, the content of this video contains general information from a publicly available case. Again, they use pseudonyms. These are not the real party names. And as always, I'm a lawyer, but I'm not your lawyer. And I hope you have a great Easter.